The markets are closed, but the business stories are just heating up. Hello, I'm Maya Rodriguez. Catch up with us on Business Brief. Asian shares are mostly trading higher in a quiet session, even as Wall Street slipped following fresh concerns about the U.S. economy. Investors are digesting a wave of corporate earnings to gauge how businesses are coping with the impact of President Donald Trump's tariffs. South Korea's Kospi is currently down, while the rest are in the green. The U.S. dollar depreciates against the Japanese yen, but it is flat against the Hong Kong dollar, the Singapore dollar, and the Thai baht, but it appreciates against the South Korean won. Meanwhile, the Australian dollar appreciates against the greenback. In commodities, gold prices fall by 0.2%, while oil prices are mixed. In the crypto space, Bitcoin rises by nearly 0.7%, and Ethereum adds more than 2%. The Philippines and India have officially elevated their ties to a strategic partnership marking 75 years of diplomatic relations. President Bongbong Marcos and Indian Prime Minister Narendra Modi witnessed the exchange of 13 key agreements covering legal, science, and maritime cooperation, among others. A bilateral trade deal and the sovereign data cloud project in the Philippines are also among the initiatives in the works. To boost tourism, the Philippines and India agreed to offer visa-free entry for each other's tourists. A commemorative stamp was also unveiled to celebrate the milestone partnership.
This new apex attests as much to the remarkably rapid growth, broadening and deepening of our 75-year-old bilateral relationship. The possibilities represented by the strong upward trajectory of our two economies, as it does to the growing alignment of our interests and views on the challenges and imperatives of our time.
Bank lending climbed to 13.55 trillion pesos in June. Latest data from the Bangko Sentral shows outstanding loans of universal and commercial banks rose from 12.1 trillion pesos in 2024. The growth was the fastest since February. The increase was largely fueled by a surge in consumer loans. President Bongbong Marcos orders a suspension of all rice importation to protect local farmers during the peak of the harvest season. The ban will take effect on September 1st. Presidential Communications Office Secretary Dave Gomez made the announcement today following a meeting between Marcos and his cabinet members on the sidelines of his India visit. The move aims to stabilize local palay prices. Gomez, however, clarifies the president believes it is not yet time to discuss a possible tariff hike on imported rice. Senator Erwin Tulfo is calling for an investigation into the billion-peso investment of GSIS in online gambling firm DigiPlus Interactive. He suspects it could involve kickbacks and should lead to criminal charges against GSIS President and General Manager Jose Arnulfo Wick Veloso. Tulfo said he would ask the Senate Committee on Games and Amusement to lead the probe. He adds he supports Senator Risa Ontiveros' expose on the GSIS transactions, calling Veloso's investment decisions questionable and unacceptable.
Pinaka nakakagulat sa lahat, nag-invest ang GSIS ng lagpas 1 bilyong piso sa online sugal. Pinasok ito ng GSIS when DigiPlus' shares were being offered at a peak of 65.30 pesos. Those shares have since hit a low of 13.68 pesos. Lugi na! Tayo nga po, mga kasamang nagtatrabaho sa gobyerno, hindi pwedeng tumuntong sa kasino. Bakit ang GSIS naman? Todo taya at ginawang puhunan ang pera ng public employee sa sugalan.
there's a decent chance online gaming giant DigiPlus may not make it to the main index. That's according to Will Cabangon, president of AAA Equities, amid questions surrounding its possible inclusion in the 30-member PSE index. A source says the PSE board is taking a hands-off approach on which stock will replace Bloomberry Resorts, leaving the final decision to PSE President Ramon Monzon. Despite DigiPlus meeting key metrics, Monzon has yet to decide. He is reportedly waiting on political signals over a potential ban on online gambling. The decision was expected to come out by end July, with changes taking effect this August. The Senate is holding its 6th plenary session. They're tackling the Supreme Court's decision on the impeachment case of Vice President Sara Duterte. Let's listen in.
I am not sure about that. But one thing I can say is that if there is a mistake, a unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo pag nananakbo. Ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ng kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-taasang hukuman na gumawa ng paraan para isang tabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canaldac has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation, with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. The treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the fourth complaint were already filed and transmitted to the Senate. Eh dito pa lang, Mr. President, pilit na patunayan na barred ang fourth complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the third mode of filing of impeachment complaint. This third and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the third mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsod, Ascuna, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo? You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene ang impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, But several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi. Basahin niyo mabuti. Uli, ang dami, gagaling ng mga abogado rito. Basahin niyo. It even quoted the entire Article 11 of the Constitution, not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leodin himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwedeng mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has, the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the sake of future proceedings, let us not dismiss forthwith. And in that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag may 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po Hindi na po kailangan na i-distingue pa natin yung adjournment and sine adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ang Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress, where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Soto, and first movement of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week that we will debate on this and talk about this and discuss this matter, Mr. President. But if the minority leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the minority leader, considering that it takes precedence, Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the chair that during our all-member caucus, which the chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe here from the distinguished minority floor leader, if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, I, as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as what? As a Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules. And you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore The chair would therefore like to make some points known before we act on the motion.
Mr.
What is the
President?
pleasure of the majority
Yes,
leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so with that, Mr. President, may I move that we recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson, to ask his questions, Mr. President.
Well, first, the chair would like to thank the
Thank you, Mr.
magnanimity
President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from Cavite, Senator Lacson, is recognized for his interjections with leave, of course, of the gentleman who has the floor, Senator Marcoleta. You may proceed, sir, if Senator Marcoleta so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss, as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with us good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the majority leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go
Your
back
Honor.
to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it?
May
We
I
are in
answer,
plenary
Mr.
as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator Marcoleta, with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang suppletory application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings, inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong suppletory application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson, insofar as that is concerned, is well taken. Senator Pangilinan.
Just on the point of
Is recognized.
suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule, resolution number 39. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Mr. President,
Majority Floor Leader.
Mr. President, next to interpolate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized, Mr. President.
If I may, Mr. President, with the indulgence of the good gentleman from Taguig and Pateros, yung akin po ay
the lady may proceed.
susog doon kay Senator Lacson ng mga punto.
But, Your Honor,
It's
the
not an
chair-
interpellation yet, Mr. President. I follow up point to the point of Senator Lacson. If the SP
lady may
and
proceed.
the gentleman. Thank you, Mr. President, and with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate impeachment court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court, yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
Noted and entered into the records. What is the pleasure of the Honorable
Just a very quick intervention. Very quick, Mr. President. With the
Pangilinan?
permission of
Yes,
our
you may
committee.
proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate impeachment court repeatedly. And therefore, it is the Senate impeachment court that was also impleaded. It is the Senate impeachment court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate impeachment court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Mr. President, and we will go back to the earlier manifestations
The
of...
mic, please.
We will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate impeachment court in terms of the exclusive jurisdiction, number one, and the sole power to try and decide?
That is what we will be deciding and voting upon this afternoon, Your Honor.
Thank you, Mr.
Senator
President.
Cayetano is
Yes,
recognized.
please, Mr. President.
Thank you, Mr. President. The distinguished gentleman, Senator Marcoleta from Tarlac and Senador ng buong bansa. Sir President, initially I wanted to speak pagbotohan na po. but very interesting po yung question na bringing up ni Senator Lacson. But aside from that, Mr. President, masyadong mabigat yung crossroads na hinaharap ng ating bansa. And remember, assuming we do nothing today, I am 101% sure that on February 6, 2026, an impeachment case will be filed against the Vice President. Maybe against other impeachable officers too. So I think it is very important that mahimay natin yung desisyon, yung sentimento ng institusyon na to, mailabas hindi lang sa social media at sa traditional media ang mga puntong nagsasaliwa, meaning pong parang hindi nag-uusap eh. So at least here we disagree, but whether we listen to the minority leader or to Senator Marcoleta, we agree to listen to each other and to examine each other's points. So I just like a few minutes on some very important matters. Let me start by the accusation that because of this decision, masyado nang mahirap at wala nang mai-impeach. So may I ask Senator Marcoleta if he would give me the honor of asking him a few questions and allowing me to interpolate on 2 or 3 topics. The first one is whether or not naging imposible na mag-impeach under this decision.
The gentleman may proceed if Senator Marcoleta will so allow it.
Yes, Mr. President.
Mr. President, sabi po nung iba, imposible na daw mag-impeach ngayon dahil sa desisyon. I
Hindi
see the
po.
decision before you. I approached you last week. You've been studying it. I see your radio program. Mukhang 10 beses mo na nabasa yung desisyon at apparently, Mr. Senator, you also listen to criticism. So kung ano rin yung sinasabi ng iba, pinapakinggan mo rin. In your view, may I take note first, Mr. President, that I am glad that the Senator made a distinction na he is for the rights of everyone. He was adopted by PDP and ran with a particular party, but he is not a member of the Duterte bloc. Am I correct there?
Technically speaking, Mr. President, I am not a member of the PDP, but I admit that I was adopted and I ran in unity with some of the parties of the PDP candidates at the time.
The point I'm going at is like, I was a cabinet member in the Duterte administration, but I have not talked to the Vice President. I ran as an independent in 2022, so I speak now as a senator and not as a partisan. I assume the same, Your Honor.
Yes,
that
Mr. President.
you're giving your own personal opinion as Senator Marcoleta, not as a partisan. Of course, I assume that for everyone here, no? Regardless of our position. So, Mr. Senator, sa iyong paghimay ng desisyon, sa tingin mo ba imposible na ngayon mag-impeach ng isang impeachable officer?
Hindi po, Mr. President.
So naging napakahirap ba mag-impeach ng isang officer?
Hindi ko po alam kung bakit mahirap po sa kanila, Mr. President. Ang importante lang po, ilagay lang po sa tamang proseso. Napakasimple po kasi nung kanilang mga tuntunin, iniisip ko, sundin lang yung mga tuntunin. Ang problema po, isa man sa tuntunin, wala pong sinunod. Kaya po humirap ng humirap para sa kanila.
So, Mr. President, I'm glad you mentioned tamang proseso. I think the way the Supreme Court said it in page 95 of the decision, there is a right way to do the right thing at the right time. The problem, Mr. President, is sinasabi po nung iba, may decision na sa former decisions, meron ng definition ng initiation, and many of us here were not mere spectators there. I mean, Senator Soto, I think, was in the impeachment court, di ba, of Senator Estrada, Senator Laurentu. Senator Kiko was still on the, we were together kay Senator Corona. Senator Cheese and I and Senator Miggs were in the House during the prayer 1/3 to the Senate Articles of Impeachment, di ba? So hindi po tayo stranger sa mga pangyayaring ito. Ang punto ko, Mr. President, Senator Marcoleta, Kung hindi nagsabi ang Supreme Court ng specific na dapat sundin, pwede kong ma-interpret na baka naman masyadong mahirap. Baka naman kahit anong i-file kung gustong protektahan, hindi na siya ma-impeach. Paano na yung accountability? But is it true, Mr. President, that on page 93 of the decision, the Supreme Court actually narrated what has to be done for a valid impeachment complaint?
Yes, Mr. President.
Allow me to read. 1, the draft article of impeachment or resolution should be accompanied by evidence when made available to members of the House, especially those who are considering its endorsement. 2, the evidence should be sufficient to prove the charges in the articles of impeachment. 3, the draft articles of impeachment and their accompanying evidence should be made available to all members of the House of Representatives, not only to those who are being considered to endorse. Impeachment is an act of the entire House, which requires a qualified minority of only 1/3 of its members to be transmitted to the Senate. However, the House of Representatives is a deliberative assembly where each member should be allowed to represent the views of their constituents. Let me stop there first. Mr. President, may problema ba yung number 1 na yung articles of impeachment kailangan may ebidensya?
Wala pong problema doon, Mr. President.
Hindi ba ho baliktad? Kung walang ebidensya, may problema.
Tama po.
Kasi kung walang ebidensya, ano yon? Tapon mo sa Senate, bahala na si Batman. So precisely tama ang Supreme Court that even if 1/3 endorse or file, dapat may ebidensya na. Let me go to the second part. The evidence should be sufficient to prove the charges in the article of impeachment. Mr. President, tama po ba na iba po yung sufficiency at iba din po yung quality or yung burden of proof? Di ba?
Opo.
So halimbawa po, sa piskalya, hindi po kailangan sa piskalya beyond reasonable doubt.
Probable.
Kailangan lang that there is probable cause that a crime was committed and there is probable cause that the accused committed that crime.
Yes, Mr. President.
So in the same manner, hindi sinasabi dito sa 2 na kailangan mo ipresenta sa mga congressman lahat ng testimony, lahat ng ebidensya. Ang kailangan lang, if you assume the evidence to be true, it will be enough to convict.
Tama po.
Because if not, then sayang lang ang oras natin sa Senate. Kung may articles of impeachment ka, walang ebidensya or may ebidensya pero yung ebidensya is not sufficient to prove the charges, either the Senate will be a kangaroo court and convict without evidence or we will be wasting our time. So wala rin problema sa number 2, Mr. President.
Wala po, Mr. President.
Number 3, ang sinasabi lang ng number 3, kahit na pumirma yung 1/3, kailangan ipakita pa rin sa lahat ng Kongreso. Isa po sa hinanakit po yun nung bata ako dahil ako po'y payat nun at hindi katangkaran. Parati akong saling pusa sa basketball, baseball, volleyball, dahil hindi po ako ganong kagaling sa sports. Sa Congress ba, hindi ba tamang rule to? Na kahit wala ka sa majority, kahit wala ka sa qualified minority, kapag ka may impeachment, merely being elected as a representative of the district or of the party list, dapat ipakita man lang sa iyo yung articles of impeachment at saka yung ebidensya.
Tama po kayo. Wala man lang po akong nakita sapagkat ako po hindi isinali sa pakakitaan ng...
So naiintindihan niyo po kung paano maging saling
Hindi ko
pusa.
nga po alam na meron na po pala. Hindi man lang kami binigyan eh. Kaya nung tinanong ko po yung aking mga kasama, kayo pala binigyan, bigyan nyo nga ako ng kopya para mabasa ko. Wala rin kami. Paano nyo pinirmahan? Hindi naman namin binasa nung pinirmahan na. Basta meron lang binigay ng mga signature pages. Doon lang kami pumirma. So hindi nyo nabasa? Hindi.
God and the world has a way of correcting itself because now I have the privilege of serving the people here, not as a saling-pusa, and definitely, Your Honor, as chairman of the Senate Blue Ribbon Committee, is not a saling-pusa here in the Senate. In fact, you are an esteemed neophyte with a very powerful committee. So, again, number 3, is just a simple walang saling pusa rule, which is very good. Number 4, respondent have the opportunity to be heard on the draft articles of impeachment. Hindi ko na po babasahin dahil mahaba, pero basically ang sabi ng Supreme Court dito, hindi naman kailangan pumunta doon ang Vice President. Pwedeng through pleadings. Meron po bang masama dito, Mr. President, na kapag may na-impeach, bigyan man lang siya ng kopya at pasagutin muna siya sa House bago siya pasagutin sa Senate? May masama po ba dito?
Wala pong masama, Mr. President. Ang totoo nga po, sinasabi nga na dapat i-repair po lahat ng impeachment complaints, kahit na yung pinirmahan ng 1/3 o higit pa, i-repair sa Committee on Justice. Yun po ang paraan siguro para magkaroon man lang ng pagkakataon ng Vice President, kahit na by pleadings lang, makasagot siya.
Yeah.
Pero hindi nga po ibinigay.
Before I go to number 5, just because I like your answer, Mr. President, one thing that guides me, no? So in coming to my decision with this, I follow 2 books. One, the Bible, which is of course a covenant between God and people, tayo, and the Constitution, which is a covenant among the Filipino people and the government, no? Alam mo, both books talk about due process. Ang Panginoon, nung kinain ni Adam at Eve yung prohibited fruit, nagtanong muna siya, ba't kayo nagtatago? Hindi nag-accuse, nagtanong muna, pero alam na ng Diyos. So ang ibig lang sabihin ng due process, sabi ng desisyon ng Supreme Court, magtanong ka muna bago ka humusga. So Mr. President, I was thinking, what if naging masyadong emotional yung eleksyon ng huli? And one-third of members of Congress ay naging anti-administration at ang kinahaharap natin ngayon ay isang impeachment labang kay President Marcos at pag siya'y na-impeach, magiging presidente si Vice President Sara. I wonder if all of us in this room and out of this room will still have the same paninindigan. I hope I will. I'm not judging. I am just saying, Mr. President, what helps me is those 2 books, but also to put myself in the opposite side, to put myself in that position. What if, so I'm looking, I see my good friend, former Senate President Subiri, shaking his head. So natanaw ko tuloy si Senator Kiko. What if Vice President Lenny and Senator Kiko won in 2022? And what if ang ini-impeach ngayon ay si Senator Kiko? I hope yung decision ko to support this decision would be the same.
Tama
Because
po, dapat walang pagkakaiba.
Wala saan pagkakaiba. So number 5, a reasonable period of time determined on the basic of complexity of charges must be given to all members of Congress. Kasi lumalabas po, yes, tama si Senator Soto, ibang mode yung 1/3. Pero lumalabas po mismo sa pleadings, mismo sa sinabi ng House of Representatives, wala pang 3 oras. Yung
Wala po.
ibinigay sa mahigit 200 na pumirma, samantalang ang complaint is a few hundred pages. Tama po ba?
Mahaba pong pahina lahat ang sinabi sa akin, Mr. President, at hindi po nila na kayang basahin sapagkat wala nga silang kopya. Humihingi po sila ng kopya bago pumirma, ngunit wala pong ibinigay. Yun po yung sinabi sa akin ng mga ilan sa aking mga kasamahan doon.
Yung number 6 po, Mr. President, madali kasi kailangan yung impeachable act is an act done while they were in their present office. So wala naman pong problema dyan. Meaning, kung may nagawa si Senator Cruz nung konsyal pa siya, pero ngayon Vice President na siya, hindi naman siya pwedeng impeach base sa ginawa niya nung konsyal siya.
Tama po.
So madali po yon. Number 7, at the very least to accord the opportunity to be heard under the requirement of due process in the procedure under Article 11, Section 3, Paragraph 4, after the draft Articles of Impeachment and required proof arrived at. Letter A, the House of Representatives should provide a copy of the draft articles and its accompanying evidence to the respondent and give her an opportunity to respond within a reasonable period. May problema po ba dito?
Wala po.
Kapag ka ganito kabigat, natatanggalin mo ang isang impeachable officers, tama po ba yung surprise?
Hindi po.
Parang, eto yung wag mo nang tignan, 1/3 naman kami, sa Senado ka na, sa Senado ka na mag-reply. Letter B simply states that all members, again, it's the walang saling pusa. So, Mr. President, in other words, it is not true that it is now too difficult. Sundin lang yung page 93, 94. Whether it's February 6 for the Vice President or if anyone wants to file an impeachment against anyone, magagawa to at any time.
Tama po, Mr. President.
Let me reverse my question, Mr. President. Dapat ba maging madali mag-impeach ng isang officer? I'm asking, of course, your opinion that I value, Mr. President.
Depende po sa ini-impeach na opisyal. Pero kinakailangan po hindi dapat magmadali. Kaya dalawa po kasing bagay yun eh. Kailangan po siyang mapagbigyan ng due process niya at gaano man po karami yung ebidensyang inaharap sa kanya. Bigyan natin siya ng pagkakataong makasagot. So maaari pong mahirapan ng konti, tumagal ng konti. Ngunit kailangan po natin ibigay lahat ng proseso sa ini-impeach at sa mga nag-i-impeach.
I value your answer on due process, Mr. President, and that's my second point. But if you would just also accept, or maybe I can put on record, I'm of the personal view, hindi dapat maging madali mag-impeach ng isang impeachable officer. Bakit po? Unang-una, iilan lang po sila sa ating bansa. Ombudsman, member of constitutional commissions, President, Vice President, Supreme Court. Hindi dapat madali dahil it's an extraordinary remedy in extraordinary circumstance not to penalize them, but para protektahan ng ating bansa at para nga po alisin sila sa equation if they will damage our country. So, the difference po with this impeachment sa iba, at least the impeachment of President Estrada, President Arroyo, and again, may I be sensitive especially to my friends here who are of that administration, was with us, against us, or like Senator Jingo and Senator JV. Yung feeling kasi doon is that if there was another day na hindi na-impeach, magagamit yung opisina na yon. Kasi presidente pinag-uusapan. Ganon din sa Chief Justice, na habang nandun ka, ma-impluensyahan mo yung korte. Pero pag pinag-uusapan mo Vice President ngayon, wala naman siyang hawak na departamento. Wala siyang hawak na agency. Wala namang police, militar, NBI, Coast Guard, whatever under sa kanya. Yes, we should hold her accountable kung may ginawang mali. Dapat i-impeach pag may ginawang mali. Pero it's not true that today and tomorrow matters that much. Because wala naman siyang opisina na magagamit not only to cover her tracks or to damage the country. Di ba? In fact, I doubt kung walang perpetual disqualification yan, baka iba ang suma natin ngayon. But I don't want to go to the political aspect. The point I want to make, Mr. President, is para tayong nag-Goldilocks, pag gusto natin yung i-impeach natin, so nung time na yon na gustong impeach si President Erap, padaliin natin. At kung hindi, walk out tayo. Kung kakampi mo si GMA, pahirapan natin. Kung kakampi mo si Duterte, pahirapan natin. Di ba? So, in that point, I see why the Supreme Court, they made a statement Nag-statement sila about history. Sabi ng Supreme Court, ito po, sa page 94, we understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those that are society's margins, or those who have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, have obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. Kung ito lang po ang sinabi nila, Mr. President, sasabihin kong hindi ba namumulitika yung korte? But sinabi nila to after page 93 na iniisa-isa nila paano mo i-impeach . So parang nga tinuruan na ang Senado at saka House, gusto nyo impeach ang Vice President o sino man, sundin nyo lang to. Wala na kayong problema. So I think in that sense, Mr. President, it's a balanced decision. Ang question, Mr. President, yung tanong ni Senate Minority Leader, former Senate President Soto, operative fact, Mr. President. Mr. President, may I venture to answer the question of Senator Soto nung tinanong niya, ano to? Diba? Ano to yung nag-robe, etc. Nasagot na po kasi ni Sara Geronimo yon. Nung sinabi niya kay Coco Martin, there was never an us. There was never an us. Sinabi kasi ng Supreme Court na void ab initio to. But I have a reason, Mr. Minority Leader, former Senate President, and Senator Ping, why I bring this up. Because I agree with Senator Ping na ano ang i-dismiss natin. Because ang sinasabi ng Supreme Court, and that goes to my last point, for your consideration, Senator Marcoleta, sabi ng Supreme Court, there was never an us, ibig sabihin, void ab initio. So wala tayong i-dismiss. So theoretically, if we do not do anything today, we are following the Supreme Court decision. Except, that's why I'm agreeing with you. So agree with me when I'm agreeing with you, Mr. Senate President and Senator Ping. However, human nature is that if we do not do anything, people will say it's pending. And we do have the 1-year, one filing bar. So the Constitution did not intend that every single day of your life as ombudsman, as vice president, president, may nakatutok sa yung impeachment. So it is also fair to the vice president that we dispose of this. The question now is, if it is void ab initio, why did the Supreme Court not apply the doctrine of operative fact? In my research, 2 reasons. One, hindi po bringing up ng House of Representatives ito. Bringing up po to ng House of Representatives later on in the MR. Number 2, there is a rule that kapag ka magkakaroon ng injustice or may ma-oppress, hindi pwede yung operative fact. So since my finding, please correct me, Senator Marcoleta, if I'm wrong. Since my finding po ang Supreme Court na sinircumvent yung 1-year bar, hindi ka ngayon pwede mag-operative fact kasi para mo ni-reward ngayon yung circumvention. Am I correct sa
Yes, Mr.
pagkaintindi?
President, because the doctrine of operative fact is based on equity and fairness. Wala pong equity talaga eh. Hindi po sinunod ang mga tuntunin. So, sa umpisa pa lang, nagpalusot na, kaya hindi po pwedeng gamitin yung operative fact.
I see former Secretary Jeremiah Bellica in the crowd. Sa ease of doing business na si Majority Leader and si Senator Ping, I think, were the sponsors, di ba, or the authors of the law. I don't know kung, ang alam ko, covered ang Congress doon eh. So kapag ka 10 days, at kasi ministerial yung sabi ng Supreme Court eh. Kapag ka nag-file ka ng impeachment, yung 10-day, 3-day, ministerial yon. So even if you do not consider it archived, if you apply the ease of doing business law that Secretary Jeremiah Bellica used to very much push in government, you would come to the same conclusion. Eh. My point is, Mr. President, we'll never come out with a perfect decision. People will disagree. That's why I agree with the statement of the IBP na ang kailangan sa Constitution ay hindi agreement, kung hindi adherence. The North and South of the United States did not agree on slavery. That's why they fought a civil war. Because they had to see who will adhere to this Constitution, who will treat this piece of paper as a living soul and a covenant of this country rather than just a piece of paper. And grabe po ang devastation sa United States. Buti po tayo nagdidebate lang. Buti po tayo yung dugo ng ating mga bayani ay minsan lang po inalay at ngayon nagdidebate na lang tayo sa desisyon na to. Pero kung hindi natin susundin ang Supreme Court decision and we will court a constitutional crisis, we will tear the Constitution apart. Because, Mr. President, this is going to second to the last question. May option ba tayo not to follow the Supreme Court?
Wala po, Mr. President.
So it's for academic discussion and for criticism, for enlightenment, and trying to influence the court na masama decision nyo. In accordance, I respect the opinions for those who think na masama yung decision. But in actuality, as an institution, we have to follow, hindi po ba?
Tama po, Mr. President.
Is the gentleman a member of the Commission on Appointments?
Wala pa po yatang ini-elect.
Hindi, kasi may decision ang Supreme Court kung paano hati-hatiin yung membership ng CA. Kung hindi rin natin susundin yung decision ng Supreme Court sa impeachment, wag na rin natin sundin sa CA. What about sa sweldo ng mga senador? Di ba, sabi sa konstitusyon, sa mga batas, hindi tayo pwede magpasa ng batas na makikinabang tayo.
Tama po yun.
So kung disagree tayo, wag na rin natin sundin dahil mas mataas na sweldo yon.
Kailangan po kasi palagi nating isasaalang-alang kung anong sinasabi ng desisyon ng Korte Suprema at hindi yung sarili po nating nilalayon o ang sarili nating interes.
Correct ko ba? Especially when we disagree. Madali kasi magsang-ayon pag we agree eh.
Tama po.
Maraming magsasabing nag-uusap tayo through microphone but we agree on many things. But mas mahirap when we disagree.
Tama
So,
po.
Mr. President, so since we disagree slightly on dismiss, would the movant, the distinguished senator, consider na ma-amend yung motion that the Senate obey or follow or anong tamang salita na acceptable sa minority, the Supreme Court decision? Because if the motion is to obey the Supreme Court, so if the Supreme Court reconsiders, the motion still carries, then we will follow. If they don't, we will still follow. And right now, sabi naman nila, it is immediately executory. So as far as I'm concerned, it doesn't exist. But I agree with the gentleman, there's some action that is wanting eh. Kung hindi, it's there floating in the air. Anyway, I leave that as a question. There might be some people who want to interpolate, Mr. President, but may I offer that solution? We are allowed to amend, to propose an amendment to any motion if the movant agrees.
I am amenable to an amendment, Mr. President, like moving it to send it to the archives. Like we will have the same result if that is the case. And I will be pleasing Senator Soto if I do that.
What is the pleasure of the Honorable Soto, the distinguished Minority Floor Leader?
Thank you, Mr. President. It grieves my heart to disagree. I think I'd rather call for the previous question, a motion to table. It has the same effect, and you can bring it up anytime. But we did not say that we did not follow the Supreme Court decision. It will not. It will not say that we archived, as the interpretation of the Supreme Court is kung ano yung word ng archive. Iba yung archive nila eh. Hindi pa nga adjourn, archive na sa kanila eh. Hindi ba? Hindi pa tapos yung session eh. Hindi naman ganun ang archive sa atin. Sa kanila ganun. Iba yung rules ng Congress eh. Iba yung kaysa sa rules nila eh. So, hopefully, baka pwedeng we can find a middle ground between the proposal of Senator Alan Cayetano and my motion to table, which has a higher precedence than the motion to dismiss.
But Mr. President, that is not consistent with the immediate character of the decision. The decision says it is immediately executory. A motion to table, hindi po immediate yun eh. Tsaka sabi nga ni Senator Cayetano, somehow there should be some action. The people are waiting for some kind of a closure before this chamber. Because that particular decision is directed to no one but to the Senate, Mr. President.
Sir President.
Before the chair recognizes any member, The parliamentary status is that a motion was made by the Honorable Marcoleta, which he is willing to amend, and a higher order of precedence motion was made by the Honorable Minority Floor Leader. Both are pending, and to afford time for both the Minority Leader and the original movant to perhaps consider and find a compromise as agreed upon earlier, can we proceed with the interpellations and interjections? Manifestations, if you will,
Yes,
of the
yes.
other members who had manifested to so interject and make known their position through a manifestation or interpellation.
Yes, Mr. President.
Thank you.
Therefore, I withdraw the call for the previous question, and then allow that to proceed. But then again, just a point of information for our colleagues. The Supreme Court has just received a motion for a TRO for the Senate not to take up this particular case. It was filed yesterday by the
Someone filed.
former Associate Senior Justice Tony Carpio, also Ombudsman Conchita Carpo Morales, Commissioner Heidi Mendoza, religious leaders, former military and public servants, Ms. Sheila Magno, students and the youth and the academe. They have filed a TRO with the Supreme Court, and we are awaiting something to that effect. It might come out today, and then we are, again, inuunahan natin. So hopefully, yes, we can proceed, Mr. President.
Thank
I
you,
have
thank
no
you,
objection.
Minority Floor Leader. Your manifestation is duly noted. Senator Cayetano.
That's the Senate tackling the Supreme Court's decision on the impeachment complaint against Vice President Sara Duterte. Senator Rodante Marcoleta moved to dismiss the complaint, but that was countered by Senate Minority Floor Leader Tito Soto. Senators Ping Lacson, Risa Ontiveros, and Kiko Pangilinan want the Senate to wait for the Supreme Court resolution on the motion for reconsideration filed by the House of Representatives. And just to add to that was what the Senate Minority Leader had said earlier, that wouldn't it have been or wouldn't it be more prudent right now to also possibly wait for this motion filed by Isang Bayan that asks the Supreme Court for a TRO or possibly even a status quo ante order with regards to the earlier decision of the Supreme Court to reconsider calling the impeachment complaint against the Vice President as unconstitutional.
Meanwhile, Senator Alan Peter Cayetano interpolated Marcoleta on the possible impact of the Supreme Court ruling on future impeachment cases. Marcoleta says the ruling will not make future impeachment cases difficult for as long as rules are followed. I'm Robert Tan. Tune in to Billionaire News Channel's YouTube and Facebook page for the ongoing Senate debate.
And I'm Pinky Webb. More details on the Senate debate on the impeachment complaint against Vice President Sara Duterte coming your way in Agenda at 6 p.m.